Get started. So, welcome everyone. Happy April, and things are progressing. I'm hoping most of us have gotten at least one vaccination and are well on our way to being free men and women again. And tonight we're delighted to have back for his annual presentation, local attorney Andrew Alder-LaRue, who is going to give his annual HIV in the law update. So Andrew, welcome back. Thanks for joining us, and take it away.
Thank you for having me. It's lovely to be here, and sorry I can't meet in person, but hopefully next year in Jerusalem, as they say. I'm a local lawyer here. I have been a lawyer come the 29th of May. I will be a lawyer in California 40 years. And I have to say, I'm pretty shocked by that development. But anyway, I've seen a lot in my time, as we all have. So in this version of HIV in the law, I am going to focus on obviously current legal events, but I'm going to specifically talk a lot about the 14th Amendment to the Constitution. And you might wonder what that has to do with HIV in the law. So if I may, let me go ahead and proceed. I use this slide a lot, actually. Past is prologue, and I think it's particularly pertinent to invoke the lines of William Faulkner, a Southern author. Past isn't prologue, it isn't even past. We are sort of back to the future. HIV in the law is what's next. Usually I begin, as I will this year, with a brief overview of the status of the criminal law and HIV. HIV has gone through a number of iterations over the last 4 decades since it dawned on us in the early 80s in terms of how the law deals with the disease and those of us who are HIV positive. So this is the current state of HIV criminalization as of at least 2020. I don't believe that this has changed much since the advent of 2021. There are 37 states that have some degree of criminalization of HIV and behavior for those who are HIV positive. 26 of the states criminalize or control this through actual specific HIV statutes, criminal statutes or regulations. Here. And 11 states, including California, attempt to regulate HIV through not criminal statutes, but through statutes pertaining to communicable and infectious diseases and sexually transmitted diseases. And 3 states, the 3 darker states here, Alaska, Colorado, and Massachusetts, don't criminalize HIV, but they use it as an enhancement at sentencing. Say there's an assault case or something, it is used as an enhancement in those states. And then 11 states have no criminal provisions for HIV at all. If there is any action or assault or whatever, HIV status might come into play, but it is not specifically proscribed in these states. Again, criminalization is a state law function, not federal. There certainly are federal statutes, federal criminal statutes, but they don't encompass HIV or HIV status, except in the area of blood donation and, of course, the area of federal prosecution. And we all know that Representative Gates from Florida, if I'm saying his name properly, is now dealing with a possible federal crime, but who knows where that will lead. But since he is involved, we all find that somewhat interesting at this point. The obligation, if you're HIV positive, generally is, it's a good thing. Disclosure is, full transparency is always important. And in some states, indeed, full transparency is mandated by the criminal law. The maximum sentences for HIV-related crimes range from less than 10 years in some states to life in prison in others. So there are indeed, even though HIV is, for many of us, well controlled by medication, it is not the issue that it was 40 years ago. But many of the statutes that pertain to HIV were passed in the 80s. Some of them have been moderated, others not. But in the last several years, many states, California among them, 5 states here named, have either decriminalized HIV in keeping with medical practice and expertise and recommendations. And then other states have HIV as a crime if you have an intent to infect someone, which is very difficult to show. And then interestingly enough, in other states, mitigation is shown or evidenced by the fact that you might be on PrEP, that your HIV is well controlled. So from the status of the law 40 years ago or 35 years ago, when things became quite criminal, the law has advanced along with medical science. And so that's an important thing to keep in mind. And I think these kinds of moderations in law will continue as HIV becomes a chronic manageable disease and less of the big bugaboo that it was perhaps in the 1980s. But, you know, I use this slide a lot. I have to say that I'm from Texas. I was in the Navy, so my vocabulary is often quite salty. And this is my general what the fuck expression evidenced by this guy who brings us to the new evidence on HIV. This is just an article that appeared in The Guardian. So as medical science advances with respect to HIV, and indeed we are all aware that some advances in the treatment of COVID and the development of COVID vaccines derive from many years of HIV research. But in researching this, this piece for this evening, I ran across this article. I always note articles of interest. I read widely. And so I think we are going to enter an era where the treatment of HIV is going to become, hopefully, much more universal than today. And with, you know, there's possibilities of developing treatments. You know, both Moderna and Pfizer developed their COVID vaccines through mRNA technology. And I understand that this has given a real boost to people who are studying HIV and who have for many years. So in 2 or 3 years, the discussions that we have about HIV in the law may be very different than the ones that we are having even today. So we always wonder what's next. But when you're talking about anything pertaining to HIV, you're always talking about the law, and not only the criminal law, but basically you're talking about this. And by this, I mean the Supreme Court. Ultimately in the United States, the law is what the court says it is. That's a derivation of the 1803 case Marbury versus Madison, which established for the first time the principle of judicial review. The Supreme Court was in fact an equal branch of government at the time of the ratification of the Constitution, but it was only in the early years of the country did the Supreme Court effectively arrogate to itself the idea that Congress enacts, the president puts into effect, but the Supreme Court basically says whether a law passes constitutional muster or not. It is the arbiter of what the other 2 branches of government do. Currently, our Supreme Court, well, I have 2 pictures here. This is the Supreme Court that we had the last time I addressed you all. And alas, this is the Supreme Court we have today. Composition is very different. We are just now beginning to see, as I will discuss this evening, the impact of the court's current makeup. The 3 justices at the bottom are of recent vintage, all appointed by Trump. And where we go from here is an open question. We are all heading into the unknown, all of us, and I suspect these 9 people pictured before you. You know, I was scanning the headlines as I do every day, and this actually is an article from today's New York Times. And I put it up here today because I think it is very relevant As I have discussed in the past in these lectures, and as I will do later this evening, I have been predicting for a number of years that we are all watching a slow motion collision unfold in front of us. And that is the collision between the First Amendment's right to free exercise of religion and the provisions of the 14th Amendment's Equal Protection Clause and other provisions of the 14th, that I think with the makeup of the current Supreme Court, the conflict between those two principles, those two constitutional rights to exercise your religion freely versus other freedoms that we all enjoy, including the right to privacy, which is a foundational precept both for the right to abortion, the right to contraception, and the right to same-sex marriage. So this is really an open question. And again, this is an article from today's New York Times. So I think we all need to buckle our seatbelts and to be prepared for an extraordinarily rough time over the next 12 months to 14 months as new cases come up before the court, which very much affect everybody on this call, and indeed all of us. Last week, the Sixth Circuit Court of Appeal decided this case. It was a professor, Professor Meriwether at Shawnee State University, I believe it is in Ohio. And he had a trans person in his course. And I don't remember the details, but they're not really important. The individual asked the professor to address them by their chosen pronouns. The professor refused, claiming that he had a constitutional religious right. He did not recognize, and his religion does not recognize trans people or that journey. And he was disciplined by his state employer. He sued. He lost at the trial court, but he won at the Sixth Circuit Court of Appeal. And basically, he said that the court said that it is an infringement of the professor's religion to force him into speech in which he does not believe. And therefore, he does not believe in the concept of the reality of the trans journey. And he was therefore within his rights to refuse to address the student by their chosen pronoun and chosen name. This case is doubtless going to go up on appeal, but this was just decided. And the article that I referenced, The Hill, which is a Washington publication, basically talked about this piece, this opinion piece talks about the view of the writer, and I agree with it, that this is abuse is a constitutional right, that the notion that someone ought to be addressed by a chosen name or in a chosen fashion is a deeply personal right and ought to be respected. But certainly the Sixth Circuit Court of Appeal did not agree, and we shall all wait to see whether or not the Supreme Court is asked to weigh in on this case, and if it is, what's going to happen? So we don't know. Again, I like this phrase because I think it really is apt. The conversations that we have today politically are the same conversations that I remember as a little kid when the civil rights laws were passed. I was 10 years old in November of 1963. My father was stationed at an Air Force base in San Antonio, Texas. So on the 21st of November, 1963, my parents pulled me out of school to go and see President John Kennedy in his last official act, dedicate the School of Aerospace Medicine at Brooks Air Force Base, where my father was stationed. And the next year, in homage to the assassinated president, the Congress passed the Civil Rights Act of 1964, and then next year, the Voting Rights Act of 1965. And, you know, everything that is old is new again, as the same discussions that were had back then, which I vaguely remember. But currently, the discussions we are having now about the new bill to expand voting rights federally, the bill in Georgia to restrict voting rights, and other states coming up with similar legislation, we've heard all of this before. So it is truly appropriate to invoke the words of William Faulkner, past isn't prologue, it isn't even past. I'm going to be discussing tonight mainly the 14th Amendment to the Constitution, but just a brief history here of how the 14th Amendment came into being. It was predicated by Congress's first attempt post-Civil War to legislate on the issue of civil rights. And so there was a Civil Rights Act of 1866. Who remembers that? Not very many of us, but it was important. Interestingly enough, after passage by Congress, it was vetoed by President Andrew Johnson, the successor to deceased and assassinated Abraham Lincoln. And the reason that he gave for vetoing this bill was that it discriminated in favor of African Americans against whites. Again, you hear the echoes of the past in discussions that we are having very much today. Interestingly enough, Congress did override Johnson's veto of the Civil Rights Act of 1866, and that was the first veto in US history. Again, the Civil War amendments, there were 3 of them: 13th, 14th, and 15th Amendments to the Constitution. The 13th Amendment banned slavery. The 14th Amendment defined a citizen and other rights along with that. We'll go into that in depth. And the 15th Amendment basically prohibited states from preventing people from voting on the basis of race, color, or past status of servitude. But I want to focus tonight on the 14th Amendment. And the reason is that the 14th Amendment actually, everybody focuses on the Constitution and the Bill of Rights whenever you hear conservative Republicans talking about, the founders and the wisdom of the founders and this marvelous document of the Constitution. What is rarely acknowledged is, if you read a lot of books, as I have done on the subject, that the Constitution was basically dumbed down enough until it could get sufficient states at that time in 1789 to vote to ratify it. And when I say it was dumbed down, what I mean is that it was watered down and changed basically to appease the interests of the slaveholding states. So from the very beginning, slavery was the issue that informed the genesis of the United States. And the Constitution almost did not get adopted because of the way it was initially constructed. So when it was adopted, the Constitution counted a person of color, an African American, as 3/5 of a person for population purposes, but as a complete non-entity for all other purposes. Interestingly enough, the civil, this issue bedeviled the entire country for 70 years. The Civil War happens, and after the Civil War, these amendments are passed to try to redress these issues. Congress passed the 14th Amendment in 1866. It took 2 years for it to reach the point of ratification. And a fact I did not know until I did research for this piece is that the state of Ohio only ratified the 14th Amendment in 2003. Interesting little factoid. And another very interesting fact in terms of how it was ratified, in order to be able to send representatives back to Congress, the southern states actually had to ratify this. So many of them did so kicking and screaming, but that was their ticket back into representation in Washington after the defeat of the Confederacy. I'm going to focus here on the text of the 14th Amendment briefly. It is rather lengthy. It has 5 sections. This is the first one. I have highlighted the language that I will come back to tonight, but it basically says everybody born in the US is a citizen. If you're naturalized, you're a citizen. I'm going to come back to this at length. No state shall make or enforce any law which shall abridge the privileges or the immunities of citizenship, or deny any person the equal protection of the laws. The other sections of the amendment are important, but it's not so germane to our discussion this evening. But I find that the language here is of its era. They refer to excluding Indians not taxed. So Indians were excluded from citizenship. At that point, citizens were confined to male inhabitants, 21 years of age, etc. Remember, when the Constitution was adopted, women were not citizens. Native Americans certainly weren't. Slaves were not. And unless you were a landowning white man, you were not. Only landowning white men were citizens. And this article, 14th Amendment did change that, but you still had to be male and 21 years of age. This is given the events of January 6th of this year. Section 3 of the 14th Amendment has risen from obscurity and is now of interest to scholars and people in Congress. Basically, it says if you've engaged in insurrection against the US, you cannot be permitted, or you will not be seated in Congress, nor can you serve as president or vice president, etc. How seriously this provision is going to be taken as the evidence of events of January 6th are developed and as prosecutions go forward, I think we all are going to really wait and see. Nobody really knows, but certainly if Congress chose to expunge those who participated in insurrection, they have the ability to do so. Whether they have the political courage to do so is another matter entirely. This is section 4, basically talking about debt, also referring to insurrection. Again, for our purposes this evening, it's part of the 14th Amendment, which is actually quite long in terms of constitutional amendments. But this is part of its text. The 5th and final section of the 14th Amendment reads thusly, which basically says Congress can enforce the amendment through appropriate legislation. I want to return here now to the reason I think the 14th is so important and really relevant today. Many people, many historians and lawyers consider the 14th Amendment to be, as it were, the second Constitution, because it is here in this section, in section 1, where after the Civil War, the concept of citizenship is completely redefined. And we move forward from this amendment into the present day, and we are still arguing about the parameters and the breadth of the 14th Amendment. And as it is expanded, it bumps, as you will see, and as you probably already know from these lectures I've given in the past, you begin to bump up against a very aggressive free exercise clause in the First Amendment. And how that conflict is going to be resolved, I do not know, but I wonder. The reason I have this slide coming up next, because the 14th Amendment guarantees birthright citizenship, which a few years ago became something that we had all just assumed existed until Donald Trump said he was going to override it. Now, it's very interesting. When I was a kid growing up in South Texas, we used to travel, and on the highways in Texas, and indeed even several years ago in Arizona, there was still a giant billboard that said, "Impeach Earl Warren." Now, Earl Warren was the Chief Justice of the United States in the 60s and the very early 70s, I believe. And of course, now he is long dead, but there was a billboard still up on the I-10 between Tucson and Phoenix for many years after his death, where he wanted to be, they were urging his impeachment. That billboard was put up by the John Birch Society, which is was a very right-wing kind of organization. For years, the John Birch Society railed against the provisions of the New Deal enacted by Franklin Roosevelt. But weirdly, at least weirdly to me, the efforts of this kind of thinking and the concepts and precepts of the John Birch Society, which one used to think confined to the very shadows, have once again kind of taken front and center stage. And the John Birch Society has been urging the end of birthright citizenship for decades. So the other aspect of the 14th Amendment that I find, the Section 1, that is extremely important and is very relevant to us today is no state shall make or enforce any law which shall abridge the privileges or immunities of citizens. Now, if you stop and think about that, I'm going to go to the next slide, which is the bathroom bill, the bathroom slides, the trans issue. If you stop and think about, I'm going to go back here. No state shall make any law which is abridges the privileges or immunities of citizens. One would have to argue, I think, pretty persuasively that the ability to go to the bathroom where you would like is kind of a privilege of humanity, much less citizenship. But you see what I'm trying to illustrate here, that the provisions of the 14th Amendment are butting up headlong into the hot social topics of today. And you know, we haven't really thought much about the 14th Amendment over many, many years. We knew it was out there. Everybody is familiar with the phrase equal protection of the law. But we are beginning to see, with voting rights restrictions, with bills to inhibit physicians from being able to provide care to trans youth, these types of things may seem very 21st century, but they actually butt up and impact our constitutional framework in a very, very real way. Just yesterday, the governor of Arkansas vetoed a bill that had been offered by the Republican legislature to prevent the extension of certain healthcare modalities to trans youth. And I was a little bit surprised because he has signed into law a couple of very anti-gay bills recently. But this particular bill, he said, was a vast government overreach, and it would create new standards of legislative interference with physicians and parents as they deal with some of the most complex and sensitive matters involving young people. Well, I'm not a fan of Asa Hutchinson, who was the Republican governor of Arkansas, but I have to laud him for, I think, very clearly articulating precisely why these anti-trans bills are so objectionable, because they cut to the bone in terms of the intimate decisions made within a family about one's health care. Now, footnote, you also have to wonder, well, if this kind of rationale is applied to a bill in a conservative state with regard to provision of healthcare to trans youth, because it's a vast government overreach, new standards of interference with physicians, you have to wonder how this same governor would treat a very restrictive abortion bill, which in my view comes very close to these same kind of, it's a government overreach impeding on the relationship between patient and physician. But Arkansas has, in fact, just recently enacted the most restrictive abortion bill in the country, which is going to go up to the Supreme Court, is a direct frontal assault on Roe versus Wade. So I find, as a lawyer, you always look for consistency of principle. You want to develop ascertain what a principle is, and you apply it to different facts to try to come up with a constant, comprehensive, and understandable framework for the law. But if you read this, I just found this was remarkable. Again, I agree with the governor here, and I agree with his reasoning, but I don't see how you fail to adopt this reasoning to other issues as well. And this is also quite interesting given the fact that other states have recently adopted, and other Republican governors have adopted, very restrictive bills to prohibit the provision of appropriate medical services to trans youth. So again, we are all on an interesting journey. Another portion of the 14th Amendment is this. One cannot deny to any person within its jurisdiction the equal protection of the law. I'm going to go back a couple of slides and look at the language here. No state shall make or enforce any law which abridges the privilege or immunities of citizens. So there are certain rights that obtain to citizens that perhaps don't obtain to non-citizens. But if you go and you look at this other section of the 14th Amendment, they change the word citizen to person, nor to deny to any person within the jurisdiction equal protection of the laws. So when you wonder about people who come across the border, they are most definitely people. And if they are not here through the pathway of citizenship, they are not citizens or not citizens yet, but they are undoubtedly persons. And they are entitled to certain protections under the 14th Amendment, that is equal protection of the law. Just so there is a distinction, and the wording is important, because the difference between person and citizen is kind of evident for everyone. But the implications of these very specific words are highly important. And the more research I have done into this, I am struck that the 14th Amendment is essentially self-executing. In other words, it's been in the Constitution now since it was ratified in 1868. And we are all familiar with concepts of equal protection. But when you read the text of the amendment carefully, you see how, in a sense, it really is the beginnings of the American ideal that many of us thought were embodied in the Constitution adopted almost 100 years before it. Let me go on. I'm going to direct now my comments to the coming conflict that I have been talking about for quite some time. This is a headline in today's New York Times. And I didn't quote the entire article, but the headline really, I think, speaks volumes. There is an extraordinary winning streak for religion at the Supreme Court. We have always known that the First Amendment, part of the Bill of Rights, protects the free exercise of religion. It also proscribes the establishment of religion. And there's always a tension between many different constitutional principles. But when, for those of us who are HIV positive, who are gay, who are trans, who are lesbian, who are different in any way, our legal protections really stem from the 14th Amendment. And so the Supreme Court, as currently constituted, with the cases that are now being quite deliberately teed up by conservative litigants, they are forcing the court into a real showdown between the freedoms of the principles embodied in the freedom of religion, but also against the principles embodied in the 14th Amendment that we have just been discussing. And again, this is an article from today's New York Times. This is not remote. We are in the middle of this battle. We are in the middle of this incredible generational struggle. And I don't know where it's going to end, but the problem for the Supreme Court is, I don't think they know either. And there's a problem here. Let me move on. The concept of privacy in the United States is nowhere uttered in the Constitution. The concept of privacy has been developed over the years, mainly by these cases. Olmstead versus United States was a wiretap case. A drug runner, a rum runner from the Roaring 20s. And so the issue of electronic wiretapping came to the fore. And this was the first case to discuss the concept of privacy. That privacy concept was vastly expanded by the second case here. This is the case, Connecticut had famously made illegal any form of birth control, even to married couples. That law was passed in Connecticut, I believe in the 1860s. So Griswold basically said, the court said there is a right to privacy embedded in the 14th Amendment. And so you can proscribe birth control to non-married couples, but you cannot do that for married couples. Later on, in the early 70s, Roe expanded the right to privacy in terms of the decision-making over the idea of whether you carry a child or not. Lawrence versus Texas was a case where the Texas had criminalized, as had many states for decades, sodomy. And Lawrence, by a 5-4 decision in 2003, said, no, the right to personal privacy, personal autonomy extends to the bedroom. So sodomy laws were struck down, which formed the basis then for the court 12 years later to legalize same-sex marriage. So you've got this building tension as the religious right has latched on to the freedom of religion, or to exercise religion freely in all aspects. You've got that right buried in the First Amendment that basically is coming into conflict with the 14th Amendment. And we have seen this coming for a long time, but we have never had a decision that has come out and said that the right to religious freedom is paramount, superseding all others. There's always a balancing test in the law. Even in a case, if you go into the Palm Springs courthouse and you see 2 litigants, the judge is trying to balance interests, and that often is not an easy thing to do. But in this case, what you're seeing is a growing conflict between those who demand that the right to religious freedom supersedes everything versus those, myself and many included, who say that all rights have some circumscribing limit. My view of abortion, for example, is if you don't like it, don't have one. Now, I do understand that not everyone else has that view, and I respect that. But we have never really basically had the court define for us that your rights end where that person's religious rights begin. And I think we are there. In the past, in these lectures, I was in the Navy. I like ships. I like reading about ships and being on ships. So I tell this story. Some of you will be bored by it. You've seen this slide before. In 1956, these 2 vessels had a very unfortunate commingling in the Atlantic, 100 miles off Nantucket, the Andrea Doria and the Stockholm. They had a late night rendezvous, and lots of damage done, lots of loss of life. And the Andrea Doria sunk, and the Stockholm limps back to the Brooklyn Naval Yard to get a new nose. But the reason that I bring this up and I use this to illustrate is that there is a conflict here between the First Amendment and the 14th Amendment. And this has been a theoretical conflict in the making for the last several years. But I do personally, I believe with the current court and how it is constituted, this conflict is going to come to a head, but I'm not sure that there is an easy way out. It is one thing to tee up an argument or a case. It's like anything else in life. You better be careful what you ask for because you just might get it. You know these people. This is the famous case of Loving versus Virginia. Mildred Loving married Richard, I can't remember Mildred's before marriage name, but she married Richard Loving. And it was a crime in the state of Virginia, and they were prosecuted, and they had to go back to Washington. And eventually, the ACLU took this case. It went up to the Supreme Court, and in 1967, the Supreme Court said that these anti-miscegenation laws were unconstitutional, that you had a right to privacy, and you had a right to marry the person of your choice. arguments that we heard, 3 decades later in the Obergefell case. But the reason I bring that slide up is for this reason. This is actually a line from the brief filed in the Supreme Court by the state of Virginia in the case of Loving versus Virginia. They were articulating a religious reason why their anti-miscegenation statute ought to survive constitutional scrutiny. And their reasoning was that the Bible saith thusly. Now, at the time, in that era, with that court, that argument fell. The court said, well, maybe you have that religious belief, but that's your religious belief. But we have a secular society to run, so you can believe what you want, but if somebody else wants to get married, it's really their business. But again, everything that is old is new again. And I think you're going to see more and more of these kinds of arguments being made once again, whether the issue is same-sex marriage, which will be revisited, whether it's the issue of provision of healthcare to trans youth or to trans people generally. I mean, again, we are in for a very interesting ride. I do not know how the Supreme Court is going to deal with this. But these are really the questions, are they not, ladies and gentlemen? How far does religious freedom extend? Am I able, for example, to refuse to rent a room to you if I have a motel someplace outside of Bakersfield, because I don't believe that 2 men ought to be married or that 2 women ought to be married? I don't believe that a Black woman and a white man should be able to check into my motel. Can I deny services? One of the bills that one of the states has recently passed has basically said that you can deny services, and where is it? Is it in Georgia? That doctors can deny services to patients based on religious belief. That's extraordinary. Doctors can deny services based on religious belief. So if you come to me and you're a lesbian and you want artificial insemination, I don't have to service you. If you're a trans kid and you come to me for counseling or medical care, I don't have to give it to you. This is new under the sun, ladies and gentlemen, in our society. You know, all of these questions that we thought had been put to bed in the 60s. Do I have to offer a mixed race couple a meal at a restaurant? Do I have to offer them accommodation in my motel? They are back with a vengeance. And once you open that door, there really is not, I don't think there is an easy way to close it or limit it. So it's going to be very interesting to see how these cases that are coming up in the Supreme Court are going to deal with this new aggressive push for the expansion of religious liberty in the context of a society that has so changed. You know, we're in the middle of the Me Too movement. We all understand that Black Lives Matter. We're watching the trial of the officer involved in the death of George Floyd unfold even as we speak. And while those ideas and those issues and those problems may seem discrete and separate, they are all of a piece, because we are at this moment in time when the aggressive advancement of religious rights and the idea that religious rights are preeminent above all others, and there are people who say that, these issues are now coming to the fore, and in the next 2 or 3 years, the Supreme Court is going to be issuing some decisions with which we will be very unhappy, or someone is going to be very unhappy. But you know, their job is to split the baby, and it'll be very interesting to see how that's done. So we have come from this to this, and I think we all have to, as we go forward, trying to survive COVID as best we can, mourn those that we have lost, and deal with how we develop a more normal society, I think we need to remember the principles of the 14th Amendment. We need to understand that truly it was the 14th Amendment that gave rise to the freedoms that we enjoy. My husband is sitting directly behind me in a class at Cal State San Bernardino. He's my husband. Many of you are married. We all have rights now that we enjoy that came as a result of a lot of blood, sweat, and tears from many, many people. And much of that, I think, is at risk. And it is going to be extremely interesting to see how this court that we currently are faced with and how this Congress is going to deal with the issues of the expansion of voting rights, the provision of health care to deserving populations, the issue of abortion. Many of us thought that these things had been decided in the 60s. And the reality is that they were not. They are back with a vengeance. I don't know how this plays out, but I do know that the conflict between a preeminent right to religion and to exercise your right of religion in whatever way you want, I think is incompatible with the freedoms that we have come to expect as Americans. And, but that's my view. I don't sit on the Supreme Court. I can only tell my two dogs what to do, and even then not successfully. But we are at a very, very interesting inflection point. I think we all need to be very, very aware and involved and active, because the preservations of the right that we have fought for so many years, I think are at risk. And I think our best defense is the 14th Amendment. You know, in our personal lives, every day we meet people, and every day we have to reserve our judgments. We have to give people an opportunity to show us who they are. In a sense, we internalize, and on a daily basis, we act out the ideals of the 14th Amendment in our own lives. How do we treat each other? Do we recognize the humanity in each other? And I think ultimately, although those words are not in the 14th Amendment, that is really what the 14th Amendment is about. And I think that we live the 14th Amendment in our own lives every day. We try to judge people on how they treat us and not on the color of their skin or any other attribute. We are all human beings. We are all people making our way, and we will all shuffle off this mortal coil. And in a sense, the 14th Amendment articulates that in legalese. But we vivify it by the way we live our lives personally. And I think we need to recognize that the 14th Amendment is, in fact, the touchstone of the America that we want and the America that we all deserve. And on that note, that's my presentation for this evening. Again, HIV and the law. HIV is part of life, and we are all impacted by the law in every aspect of life. So I don't think you can have a discussion about HIV and the law without looking at the larger backdrop, and certainly the impacts or the effects of an aggressive push for absolute religious freedom will affect all of us who are HIV positive, who are in same-sex marriage, or who are in any way different from the Christian majoritarian culture. Thank you. I'll take questions now if you'd like.
Great, thank you, Andrew. That was terrific, as always. Always a pleasure to have you back. I'm already getting messages from the chat that this is amazing, and thank you for doing this. So a couple of questions have come up. One person asked about what organizations or websites you recommend for those who want to engage on the issues you raised.
Gosh, what organizations? Well, you know, I will admit not only am I a big old fag, but I am a card-carrying member of the ACLU. There are many, many organizations that I think you can get involved with. That's one, but you can Google, you know, there are so many now. There's the National Lesbian Rights Project that does a lot of good litigation, the Transgender Law Center, Stacey Abrams, her organization in Georgia, Fair Fight, which I contribute to. I mean, there's so many people who are representing so many interests. We are all different in this country, but our commonality is that we are Americans, and we grow up thinking that we have certain rights. We have certainly learned in the last year since the tragedy of George Floyd. Years ago, I went to, I used to travel a lot doing a lot of climate change work, and I went to one of the UN worldwide meetings that happens every year, Conference of the Parties, in Nairobi. And I'd never been to Africa before, but I must tell you that it was an eye-opening and wonderful experience to walk into a culture where I'm the only white face in a sea of Kenyans, and it changed my perspective. And so I think that any organization, any group, you can, there are so many I couldn't even begin to name. I just think it's important that you read widely, that you educate yourself. I think voting rights is one of the most important issues because Congress passes laws. Now, Congress, we now is on a knife's edge, 50-50. But voting rights is key because voting rights leads to participation of previously disenfranchised groups in society. Nothing is ever going to be perfect. I did not support Joe Biden for president for many years. I volunteered with his vice president's campaign 4 years ago. But, like in Texas, they say you dance with the one that brung you, which means you go with what you got. But I think there are any number of ways that people can get involved and to make their voices known. We often feel like what happens in Washington is out there, but I have to say, for my money, Stacey Abrams' group, Fair Fight in Georgia, and others like that, I think are absolutely the most important political actors on the field today. We know that the right wing, again, the John Birch Society used to be this very fringe organization, but those ideas have been brought into the mainstream by the Federalist Society, a group of conservative lawyers that got started 35 years ago. And now, unfortunately, because of Trump and his appointments, they're well represented on the federal bench. The bottom line is, even though many of you are not lawyers, and I would not ever recommend that you go to law school, I will tell you that we are all affected by the law. And it is important that we all be engaged and be aware and understand that our rights as Americans, as contemporary Americans, the rights that we live and breathe today, we owe those rights to the 14th Amendment, not to the Bill of Rights, but to the 14th Amendment, because the 14th Amendment is the articulation of the promise of true equality. And I think, like anything else, that amendment only has life to the extent that we breathe life into it. And that is done by political pressure, unfortunately. But there are many, many groups, and I just urge you all to get involved, because I think over the next several years, we are engaged in a titanic struggle. I think this play has been in rehearsal for a long time, starting with Reagan, and it has now reached a peak with Congress absolutely split in half, and with the federal judiciary very much dominated at the trial level, certainly, by Trump judges. So again, Confucius supposedly said, "May you live in interesting times," and we certainly do. Any other questions?
So while you were talking, people added a couple more groups, Lambda Legal, of course, for LGBT rights.
Sure.
And the Southern Poverty Law Center. I don't know if you can see the chat, but there's some other questions I'll ask you that people have posted. Jerry asked about the professor who refused to refer to the trans person with their preferred pronoun. Can you tell us what the legal basis was for the right to be called by one's preferred pronoun?
His claim was he was sanctioned by his university. It's a public university. And he was subject to discipline, whatever that process was. And he sued. And he claimed that the university's action in disciplining him violated his First Amendment rights to freedom of religion, because his religious belief was that, and is, that trans people don't exist, or that, God made man and woman and Adam and Eve and all this business. I mean, I didn't read the briefs, but in short, his claim was that of religious freedom. And so again, it's a perfect illustration of the kind of ultimate question: where does your religious freedom, it used to be that where do your rights end and somebody else's rights begin? And there's really no fixed point for that. It's always an argument that is contextual in terms of 60 years ago, when the Supreme Court decided Loving versus Virginia about interracial marriage. There was no same-sex marriage, was largely on no one's mind. But time and things develop. I mean, it's my personal view that I think the Supreme Court is going to continue to paint itself into a tautological corner that it is going to be very difficult to get out of. And what I mean by that is this. You can say, all right, well, so this professor had the right to not refer to a trans person in his class by their preferred pronouns. You can't make him do that. You can't violate his religious rights. Well, what happens if somebody says, I'm now asserting a long dormant religious belief that interracial marriage is against God's law? That's my sincere belief. I sincerely believe that. Well, I can tell you in 1966 and 67, the state of Virginia sincerely believed that and sincerely articulated that belief in their legal briefs. So what happens to the Supreme Court when people begin to say that? It's one thing to say, well, we're not going to recognize the rights of trans people because, that's kind of a new thing. I mean, we were just sort of dealing with the same sex thing, and now we've got this to deal with. But I think when people, the conservative legal industry, and there is one, believe me, the Federalist Society, supported by the Mercers and other money, they go out and they find these cases. These cases just cases are recruited. Don't ever believe that they're not. And I think, but once you let the genie out of the bottle, you really can't control it. So you will have somebody who claims, well, it is my religious belief that I'm not gonna rent a room. I'm not gonna rent an apartment to an unmarried couple. What's the court gonna do with that? I have my religious belief about not renting to people who are not heterosexual married couples is as strong as the religious belief of the professor at Shawnee State University in referencing trans students. Again, once you begin to go down that path, I think the court is gonna find that there is no easy way to deal with all the questions that are definitely gonna arise once you open that door.
Mm-hmm. And in regards to the transgender law you referenced earlier, Chris shared that it's just announced in the news a couple of hours ago that the legislature in Arkansas overruled his veto and now law. So. Well,
there you go. So that will be teed up. And, again, you go back to the Section 1 of the 14th Amendment. Everybody in this country is supposed to be treated equally. Well, when you have trans people who are not being treated equally, what do you do with that? I don't know, but thanks for that update.
Yeah, absolutely.
Not any big surprise.
Well, you spurred a lot of comments and questions, so I'll try to get through them in the limited time we have. So someone asked, Mary was asking about how to end the Citizens United law that gave personhood to corporations and has truly screwed up our government.
Well, no, I mean, that's actually a very good question. you know, politics is politics is a relationship of convenience. So in 2015 or whenever, 2005, when Citizens United was decided, corporations became people, they became subject to, they could contribute to political campaigns, et cetera. And then the last 2 days, we've got Mitch McConnell, Republican leader in the Senate, who is bashing corporate America, I think a bit inartfully and disingenuously. But, you know, because Coke and Delta and Home Depot and other Georgia-based corporations are now being pressured over the issue of the Georgia Voting Rights Bill. Bottom line is, I think Citizens United was a terrible decision that has completely torqued the politics in this country, because money talks. Everybody knows that. Anybody, I mean, if you've ever gone to lobby, I've lobbied in Sacramento, Washington, and Brussels. Well, it's very different in Europe. But if you go to Washington, I don't care what they say, you know, it's like, let's say in Texas, you know, money talks and bullshit walks. So it's, I think Citizens United is going to have to be addressed by Congress. And then you're going to get into another battle as to whether or not any statute that obviates or negates Citizens United is itself constitutional. I mean, after a while, you can begin to chase your tail on these issues. But I do not think that a corporation was ever meant to be a person as envisioned by the 14th Amendment. And I think it's going to take an act of Congress that is both passed by both houses and signed into law to change that. And, you know, but again, I mean, the Supreme Court is actually going to find itself in a very unusual situation. Conservatives for decades have railed against judicial activism. And yet when you have the newest members of the Supreme Court arrogate to themselves the wisdom to change decades of precedent created by other highly intelligent, mainly men, but men and women over the last number of decades on the Supreme Court, you know, you get to a point where, well, how were those smart people wrong and only you are right? But Citizens United itself, back to the question, I think that is going to that's going to require legislative redress. I wonder whether or not any legislative redress would ultimately itself be found unconstitutional, because again, you go back to Marbury versus Madison, 1803, the law is what we say it is. So, you know, we shall see. Any other questions?
Yeah, Susanna is asking, what do you think of the Federal Equity Act with its federal non-discrimination protections?
Well, I think a lot of such statutes are we are in a whole new era. The Federalist Society, right-wing lawyers, right-wing judges have been articulating the position for a long time that despite what the Constitution says, the federal government actually has very limited power. We all grew up in an era of the civil rights bills and the conduit by which Congress regulated the laws in each state was essentially through the vehicle of the vector of the Commerce Clause, that the Constitution gives the Congress the right to regulate commerce among the states. So that is how you could have bills, the Civil Rights Bill, a perfect example. The vector by which it was enforced was the Commerce Clause, that highways that ran the interstate highway system built in the 50s, a program under the Republicans and under Eisenhower, I will add, as we're having a debate over infrastructure, that those highways coursed throughout the nation, and you had motels and et cetera built up, and accommodations, restaurants and eateries and whatnot built up on the traffic ways, and you couldn't discriminate because that was something that touched on interstate commerce. The Commerce Clause gave the Congress the right to regulate what you couldn't do in the in the interactions of interstate commerce. That whole theory is up to question now, because the right wing basically says that the government, the federal government, unless there is a constitutional amendment, the federal government has actually arrogated to itself much more power than it actually has. In the 1930s, FDR and Congress created all kinds of programs to help the country out of the Depression. Social Security, a perfect example. And there is, believe it or not, despite the fact that I get Social Security, many of you do, and many people depend on Social Security. But there is a strain of thought in the right wing that Social Security is unconstitutional. You don't hear that uttered very much, partly because Social Security is extremely popular among older people who vote a lot, but nonetheless, that is one of those things that the ultra-conservative mind has for decades railed against, because it was an unwanted, unwarranted government intrusion into private life. I don't see Mitch McConnell attacking Social Security, but you will read scholarly articles from the Federalist Society doing just that.
Great, thank you.
Okay.
Any other questions or comments for Andrew? If so, just raise your hand or click on the button or whatever. A little time for discussion, and then we have some announcements. Seeing none, thank you again. This was amazing, as always, so we really appreciate it. And I'm sure there's always going to be more to talk about every year. It's ever changing.
Well, I think we are in for a very interesting 12 to 18 months. Again, I go back to the headline in today's New York Times. You know, if you're a right-wing Christian, you're riding high. We shall see how long that lasts. But I think we all need to buckle our seatbelts. Really, what I think we need to do is get down, get to work. If you can't do it directly, donate money. We need to get involved. And Godspeed to all of us. Namaste.
Thank you, Andrew. So a few announcements. You may have seen in the after the email reminder for this that we have another survey research project that we're doing. It's a resiliency survey, not unlike the one we did last year, but it's more expanded about people's experiences during COVID, asking about vaccine acceptability and things like that. So I posted the information and the link in the chat there, but it's also in that email, and it should be on our website. I can double check and make sure it's up. But if you have any questions, just shoot me an email. We'd love, this is for anyone over 50 who has been living in the Coachella Valley for the last 6 months of the pandemic, and positive or negative, because we're comparing the two groups to see if there are any differences. And there's a $20 gift card for anyone who completes the survey. So please do not post on social media. We've learned the hard way that when that happens, bots and scammers from Nigeria and all over the place bombard us, and we have to like shut things down and weed it out. So just share it with people you know would be interested, but not on social media. And we appreciate your help with that. And then Susanna from UCSD's HIV Neurobehavioral Research Program has some studies for us, and she's posted something in the chat. Susanna, do you want to say anything? Yeah, there you are. Go ahead.
Sure. I just wanted to mention to folks that being out in the desert, there are a couple of studies that we are recruiting participants for. And one of the more well-known one is the Tessa Moreland study that has to do with belly fat and lipodystrophy. So if you are interested in that study, please give us a call. The phone number is in the chat at 619-543-5098. And we're looking for folks who are 40 years and older, living with HIV, and are having memory problems. So, and also part of the study is doing a clinical trial with a Tessa Moreland to see if it can affect any changes in your memory concentration. So the drug's already been FDA approved for reducing belly fat in folks living with HIV. So that safety has already been documented. But this has to do with adding another use to the Tessa Moreland drug because there are anecdotal reports that decreasing belly fat can improve an individual's memory concentration. So we want to see if we can document this in the tesamorelin study. There's MRI. Huh?
I just wanted to jump in and let people know that this is a study that it used to be at Borrego.
Yes.
It was originally there, and then with the deaths of Dr. Scheibel and then Dr. Shigeno, they weren't able to do the study anymore, and then COVID happened, so things were pretty much shut down for the past
right.
year. And now it's going to be at Palm Tree Clinical,
right?
Site. You've probably seen them before, and they have offices over by Desert Regional Hospital.
Mm-hmm. So, you know, give us a call and we'll set you up if you're interested in that. It's the tesamorelin medication is a daily injection into the abdomen. And the study is 48 weeks, but your active participation is only 24 out of those 48 weeks. The other thing is that we still have our neuropathy and pain study. And we are enrolling a few folks from the desert who are interested in that. And this is for individuals who currently are using their own cannabis for their own neuropathy pain. It's a text messaging and study an observational study to see what, if any, changes we can document over time. It's a 6-month study, and there are 2 components to it: a daily text messaging for 6 months, and then cannabis administration visits. And the compensation is up to $570. What I forgot to mention on the tesamorelin studies, the compensation can be up to $635 if you decide to choose to do the elective cerebral spinal fluid biomarker lumbar punctures. So that's an additional sub-study to the tesamorelin study. And we're enrolling folks who are English speakers or Spanish speakers for the tesamorelin study. Then there's the California Neurotissue Aid study, and that has to do with folks who are 65 and older, who've had HIV for a very long time. And I have several people from the desert who are enrolled in that study. And and basically you just have to want to do organ donation for research purposes at the end of life. Those are the ones that I wanted to emphasize tonight. And we have a COVID study. Oh, sorry, one more. COVID study for those who are current participants at the HNRP, the HIV Neurobehavioral Research Program. If you're a current participant, we're doing those remotely via cell phones, and hopefully hope to do it via the internet. So if you're a current HNRP participant, you can enroll in the COVID study. And if you are a prior participant who's had COVID, then there are some additional visits that we would love to have you join that study and do blood draws. So that's it. If you have any questions, my number's in the chat, but also I'm going to type in my email address so that you can send me your questions. And if you have any questions about anything else related to HIV studies at UCSD, just ask. And I'll be happy to direct you. If we don't have it, I'll find somebody, hopefully, that does have one. That's it. Thank you so much for your time. I really appreciated this presentation. It was a great history and law, as well as on current law events. Thank you.
Yeah, we have those studies posted on our website as well. There's a whole section for UCSD and HNRP. I just put our website up there as well. And if you have any questions or can't remember or lost the info, just shoot me an email and I'll be happy to put you in touch. I've been involved with HNRP for 30 years now. They do great work. They've really helped people with HIV a lot. So I'm glad that they have these studies and are able to do them out here in the desert. And somebody asked about these studies being based in the desert. So the HIV and Aging Research Project, Palm Springs, is based in the desert. So that's why we talk about things available in the desert or in the surrounding Southern California area. Things in Northern California that you're asking about would be at probably UCSF. I would check there first. There's a lot of great research happening there. So definitely, and if you have any questions or want to know how to reach them, again, just shoot me an email, and I'm happy to put you in touch with the folks.
Hi, it's Jerry Boshin. Let me take a couple of minutes.
Oh, hey, Jerry.
We are doing 20 trials, clinical trials at Palm Tree Clinical Research. They cover the areas of HIV, gonorrhea, staph infection. We are also doing pulmonology studies, COPD, bronchiectasis. We are doing the Tesla Moran study with UCSD. We do GI trials, NASH included, and we are bringing up this month neurology trials, Alzheimer's and the like. So please give us a call. We've got lots of information for you. Our office number is 760-778-7799.
Great, thank you, Jerry. And I am putting in the chat a link to your website as well.
Thank you.
Go there and check it all out. Great. Any other? Also one thing we should share is that, as you may recall, there was a fundraiser for Timothy Ray Brown's memorial, both to get a boulder placed at the National AIDS Memorial Grove up in near San Francisco, and a park bench here in the Wellness Park at Ruth Hardy Park, catty corner from the hospital in the Sinatra Auditorium where we used to meet. And they're going to be putting a park bench there with a plaque and his name and so forth on it. And there will be a dedication for that on May 7th at noon in the park there, kind of the northwest corner of the Wellness Park. So once we have more details, we'll be sending those out, but I kind of want to give people a save the date for that. And for those who supported, thank you so much. You've made that possible. And we're really happy to be able to honor Timothy in that way for all he's done. For anybody else, any other announcements or comments? If not, thank you for joining. Next month will be a program on healthy eating for people living with HIV with a registered dietitian from AIDS Project Los Angeles named Jamel Lura. So we're excited to have her. And then the last program for our summer break will be on June 1st, and that will be honoring the 40th anniversary of discovery of kind of the announcement of HIV with Dr. Michael Gottlieb. And as you may recall, he was the Los Angeles physician who filed the first case reports of gay men with mysterious cases of KS and PCP, and he submitted those to the CDC in their morbidity and mortality weekly report. And that's how the world first became aware of what AIDS was. So it's a fascinating talk. He gives this kind of front row seat experience to the whole talk. And he's still practicing in LA all this time. So he's seen it all from the very beginning. So we're excited to have him. And then we will be taking our summer hiatus in July and August. Last year, we just kept going with the Zoom programs because nobody could travel, but I'm being optimistic that we can get out of the desert this summer, and we'll start back in September. And it's my sincere hope that we'll be able to return to the Sinatra Auditorium at the hospital, but that remains to be seen. So stay tuned, and we'll let you know if we're going to continue on Zoom or if we can go back to meeting in person like we did in the olden times. So. Thank you again, everybody, and we'll see you again next month. Stay well, stay healthy.
Thank you, Jeff.
Bye.